been donated, which is 30 minutes.
A battle of legal titans began on Tuesday at the Court of Appeal as notable lawyers representing the BBI proponents argued why the High Court's decision that found BBI legal, null and void must be overturned to give way for the BBI referendum.
My lords, my ladies, is that our Constitution has no place for the application of the basic structure doctrine.
The High Court made 18 declarations on 13th May this year against the BBI constitutional amendment process.
Judges cannot be tried for violation by the court. They have to go to a tribunal set up under the Constitution. It is therefore my humble submission that this finding was against the Constitution.
Among the hurdles that the pro-BBI legal team must handle to bring back the BBI reggae is whether the president is allowed by law to initiate amendments to the Constitution through a popular initiative.
And the suggestion that was made by the court, not even the suggestion, the finding, was that to that extent, therefore, the president should utilize the Article 256 route and leave the Article 257 route only to those who have no access to Parliament. And the point that I was making is that, in fact, the people have an option of going to Parliament through Article 119. So both the president and the people can access Parliament.
Leading the Attorney General's legal team, Solicitor General Ken Ogeto, assisted by lawyers George Oraro and Kamau Karori, poked holes on the High Court ruling, saying the findings that the president couldn't initiate such a process was erroneous.
When you say, can you have the president, for example, coming up with a proposal? That is a possibility, my lord. It's actually a possibility that a president can make a proposal that can be picked up and that can be the genesis of a popular initiative. But until 1 million signatures are obtained, it is not a popular initiative.
Do you see a situation where those who wield state power can make a general suggestion? To whom are they making that general suggestion?
Representing the BBI secretariat, lawyers James Orengo and Paul Mwangi insisted that eternal clauses do not exist in the Kenyan constitution and therefore all articles are amendable.
Even the supremacy of the Constitution, the provisions in relation to the supremacy of the Constitution, is amendable.
Every society has a basic structure. The question is the amendability.
Amendability.
So do I get you to say that every article in the Constitution is amendable as long as it is done constitutionally?
You got it right, my lord.
That is your...
That's our submission.
That's your submission?
Yes.
The day we get to elevating the law of man to almost being a religious law. In fact, at the High Court we say that is the height of idolatry. Because there is only one law that man cannot change. And that would be the law of God. It's the only one that you must obey. Anything else that is a law made by man, cannot conceptualize a situation in which we come up with an idea that cannot change.
This, the lawyers sought to refute High Court ruling that the BBI attempted to alter the basic structure of the Supreme Law.
There is no mention in our Constitution of an amendable or eternal clauses in our Constitution.
The legal arguments did not go without a challenge by members of the bench who are keen on specific issues.
In the circumstances of this appeal, did the president initiate it in his personal capacity or in the official capacity? That appears to be the tension in the judgment of the High Court.
The finding by the court that the reason why the president should not be involved in the popular initiative was purely because the president has the option of going to Parliament.
The BBI Secretariat and ODM leader Raila Odinga, through lawyer Otiende Amolo and others, will present their case tomorrow. Giverson Minor, K24, Nairobi.